Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 377 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by my new book, The Complete Compliance Handbook. This book is a one-volume compilation of practical and targeted compliance solutions that you can use for years to come and will be an essential guide for everyone in the compliance community: compliance officers, legal professionals, senior managers, board members, government prosecutors, and regulators. In less than 10 minutes a day, busy compliance practitioners can master key compliance subjects in less than a month by following each chapter's regimen of up to 30 daily readings and bullet point summaries on a specific topic. The Complete Compliance Handbook is available for pre-order on my website, www.fcpacompliancereport.com, and will be released in late April by the publisher Compliance Week. Today I have with me Tom Sporkin. Tom is a partner at Buckley Sandler in Washington, and he is a whistleblower lawyer. He is a former chief of Office of Market Intelligence at the Securities and Exchange Commission. We continue the discussions I've been having about the recent Digital Realty Trust versus Summers case, and we discuss the ruling in terms of not only what it means for whistleblower protection, but Tom also talks about it, how it interplays with the Sarbanes-Oxley Act and protections that are available for whistleblowers under SOX. It's a fascinating exploration of all of the protections and benefits available to whistleblowers under federal law. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for another episode. And today you're in for a real treat because I have Tom Sporkin with me. Tom is a partner at Buckley Sandler, a law firm in Washington, and he has what I would characterize as a whistleblower practice. Tom was at the SEC for over 20 years, ending up as the chief at the Office of Market Intelligence. We were at a conference last week and had the chance to talk about the Digital Realty Trust versus Summers case. So I asked him if he would come on the podcast and talk about it. So Tom, with that fairly long-winded introduction, thank you and welcome.
Thanks, Tom, and thanks for having me here today.
So this case really has a lot of implications in many layers, many levels, many groups, and you are an attorney who represents whistleblowers before the SEC. So I thought it might be great if I could get your perspective, maybe starting with how did this case get to the court? It seemed to have a winding path, or at least the issues did.
Sure, and I think we need to start back in 2002 when the Sarbanes-Oxley Act came into existence. That was really the first big whistleblower provision that was inserted into the securities laws, and that was a retaliation provision. And as you recall, that came about because Sharon Watkins, who was an employee at Enron at the time, had identified what she believed were suspicious accounting practices. And so she sent an email to Ken Lay, who was the chair on the board of directors and the chairman. And Ken Lay was kind of not really up to the task of having day-to-day management and didn't really look at it closely enough. But when it came after Enron blew up, and it came out later in her congressional testimony, she said she was scared to give it to Skilling and Fastow, the CFO and the CEO of the company, because she was scared she would be retaliated against. So the Sarbanes-Oxley Act was designed to allow for and encourage individuals who might otherwise have been fearful of retaliation to report observations of wrongdoing up the chain. In contrast, in 2011, in reaction to missing the Marco Polis tip, the Dodd-Frank Act included in the whistleblower provision. It was primarily designed as a reporting provision to the SEC and a bounty provision, so you could actually make money for the first time. And the retaliation provisions were really looked at as they weren't as important as the reporting provisions. They were meant to help people feel like they wouldn't get retaliated against if they reported information to the commission. However, So it's important to understand that this was primarily a bounty provision with a tacked on retaliation provision. Subsequent to nevertheless, there is a provision in the retaliation side of the legislation that says you are a whistleblower if you report information under the Sarbanes-Oxley Act. That's in direct contrast to the other provision in Dodd-Frank that says you must report information to the commission. And that's really how courts after 2011 dealt with this issue, primarily district courts. But then there were three major circuit court opinions that dealt with this issue. First, the Fifth Circuit didn't give deference to the SEC's rule, and they said that if somebody doesn't report to the SEC before they're fired, they don't get the Dodd-Frank retaliation provisions. Then the Second Circuit said, no, we disagree with that, and in a split decision, the Second Circuit said, we are going to give deference to the SEC and their rulemaking, and we are going to give retaliation protections to people, even if they report after they're fired. Then in 2017, the Ninth Circuit in the Digital Realty v. Summers case said, we're going to go, we're also going to agree with the Second Circuit. We are going to accord retaliation provisions to someone, even if they report after they're fired. But that, again, was a split decision. And that then provided the avenue for the Supreme Court to finally decide this issue once and for all.
So on the court's ruling itself, what were your thoughts?
So the Supreme Court unanimously decided not to give deference to the SEC and said, black and white, you must report to get the retaliation provisions under Dodd-Frank, you must report your observations to the SEC before you're fired. The court dealt with all of the background that I had just described. The court dealt with in the opinion and said, look, primarily the SOX Act is the retaliation provision that was primarily devised to protect people in reporting observations internally. SOX, the Dodd-Frank Act, in contrast, was meant to help lubricate people to report information to the SEC to win bounty awards. And so the court dealt with those two competing provisions, the one that says to the commission, a requirement of to the commission, versus the other provision that says in making disclosures that are required and protected under Sarbanes-Oxley Act. And the court said, no, it has to be to the commission. Making SOX disclosures do not necessarily in and of themselves protect you or get you the retaliation provisions.
So one of the things, Tom, I've been exploring is the implications of this case. And although you did not work in the office of the whistleblower while you were at the SEC, you were certainly aware of whistleblower tips that would come in. Could you really talk about how the SEC uses that information?
Yeah, well, and I think it's important to understand where corporate America was when these rules were being promulgated. So if you recall, Dodd-Frank comes up in 2010, and the mandate is on the SEC to write rules to effectuate the statute. And so I can't tell you, when I was there, I was one of the supervisors and leaders in the rule writing, the Dodd-Frank rule writing. And I can't tell you the number of lobbyists, corporate attorneys that came in and asked us to please add a provision that required internal reporting as an element of being allowed to be a whistleblower, a bounty seeking whistleblower. They said, please make sure that you put a provision that says people must report internally. Well, that wasn't consistent with the statute, so we couldn't do that. But what we did for the corporate America is we said, look, we're going to give you a 120-day rule, which says whistleblowers who report internally are still eligible for the SEC award, and they keep their place in line if they are loyal to their company and report internally. So that would be something that a corporation could advertise to its employees. Look, we will take your matter seriously, and we will log when you report it if you then want to go to the SEC. The other thing we gave them was tacking, which we said all the information that a corporation does accumulate, if it does an internal investigation, will get tacked on to whatever submission the individual eventually makes to the SEC, which will then give them a bump up in the determination of what percentage of an award they might get at the SEC. And finally, we gave them another gift, which was what I call the bump up, which is if you do report internally, you just generally, when the SEC evaluates your tip, you will get a slight bump up. So those were some of the gifts that we gave corporate America as part of the rule writing. But I got to tell you, I don't think they really cared. What they really wanted was that obligation to internally report. So this is a long way of saying that I don't think corporate America has ever been happy with this. And I refer to the Digital Realty case as Digital Realty won the battle, but corporate America lost the war. And I think a lot of corporations who hire labor lawyers to fight these whistleblower cases, they look at these with very narrow, how this impacts us now, not how this is going to impact corporate America. And so they fight, they engage in scorched earth tactics to fight their own internal employees. And what they don't understand is that this has the potential to create a scenario in which employees are no longer going to trust that going internally is in their best interest. So I think that's important to note. And what I saw at the SEC I saw a handful of good tips a day after the whistleblower provisions came to pass. And I got to believe that now after this decision, you're going to see a lot more reporting to the SEC. And Tom, I'm not sure whether it's all going to be valuable reporting. I think a lot of it might just be in anticipatory and protective reporting that employees do, because now they know, and every whistleblower lawyer out there knows and is advising employees who call them, you've got to get to the SEC immediately so that you get these retaliation provisions.
Well, Tom, in addition to some of the difficulties that you've articulated that I think this decision and will bring to corporate America and compliance programs generally, I think it also puts a lot more pressure on the Securities and Exchange Commission, and because of that, a lot more pressure on people like yourself to really engage in a vetting process so that when you submit a claim to the Securities and Exchange Commission, the Commission has a high degree of confidence that someone experienced with a jaundiced eye has looked at this, has looked at the evidence, has looked at the documentation, and the filing is not simply to protect themselves from retaliation, but to bring substantive information to the SEC. And I see someone like yourself as probably having to vet just a lot more claims now. Do you sense that? The challenge you point out is very accurate. As whistleblower lawyers get inundated with more, contact by employees of public companies, the whistleblower attorney himself or herself has to be very, as you say, just naturally skeptical, because a lot of times, whistleblowers have an axe to grind. I can't tell you the number of times that is, in my practice, both at the SEC and now here, I got to tell you, you can probably count on one hand the times that there wasn't an axe to grind. So really, when you vet a whistleblower, you look at whether they're the legitimate, meritorious whistleblower as opposed to the opportunistic whistleblower, and that is tough. And it's important for people like me to maintain a good reputation at the SEC, so that when I do bring a matter to the SEC, they immediately, their head perks up and they say, "Oh, this is from Tom Sporkin. I'm going to take a close look because he only gives us good stuff." So from that perspective, if a whistleblower lawyer cares about his reputation, he or she has to do a better job. And the SEC, the prior director of enforcement it has a speech from 2016, I think September of 2016, where he specifically says, we rely on good whistleblower lawyers to help us do our job. So one of the things that you mentioned a little bit earlier was the interplay between Sarbanes-Oxley and Dodd-Frank. And I was wondering if you could kind of go through not only how those two statutes interplay, but the protections that a whistleblower might be able to avail themselves of under Sarbanes-Oxley that don't exist in Dodd-Frank, and how you might advise someone to consider their steps.
Okay, so not all is lost, as the Supreme Court points out. SOX is a very powerful statute. The only the two main differences between SOX and Dodd-Frank are in SOX, you have to report. You can be fired and then report your retaliation and still be protected in SOX, but you only have 180 days to do it. You got to report it initially to the Department of Labor. And then you have to wait if you want to get, there's a kick-out provision that allows you to subsequently file your action in federal court, which you have to wait, I believe, another 180 days. So not all is lost. The kicker is you've got to get something on file with the Department of Labor that articulates how you were retaliated against and what your observations of the violations were within 180 days. And sometimes what happens is employees wait too long before they call a lawyer. You know, they have second and third thoughts, they have doubts, and they finally pick up the phone, call a lawyer, and those rights that time frame has lapsed. So that's the first big issue, the big element that differs. The second is Dodd-Frank. I'm sorry. Let me also say Dodd-Frank has a 3-year statute of limitations, and a maximum of a 6-year if you go from the date of discovery of the violation. So that's a much longer period of time for a whistleblower and a whistleblower lawyer to get involved and report to file a retaliatory case. The second area is double back pay. Dodd-Frank has a richer provision as far as when you do the multiplier and you figure out your damages that you claim in your case. Dodd-Frank allows for double back pay. So if you're an employee and you're making $150,000 a year, you can immediately sue as part of the back pay portion for $300,000. SOX is single back pay. Those are the real differences in the statute. There are other minor differences which talk about both are reasonable belief standards, so you don't really need the violation. It's just a reasonable belief in the eye of the complainer that there was a violation of law. Those are pretty similar the way they each of the statutes articulates that provision. It's really those two things. It's the statute of limitations and the double back pay.
So with those two statutes in place and overlapping and with both overlapping in different provisions, how does a person proceed through all this, starting with the first conversation with yourself? Yeah,
so this is an interesting area. Dodd-Frank, SOX, corporate employee whistleblowing is a very dynamic area, and it requires, I believe, a very sophisticated lawyer in two areas: securities law and employment law. And if you don't combine those two disciplines, it's possible that a potential whistleblower could not get the best strategic advice on how to proceed. So if you think about it, the underlying substantive observations are securities related. So if you're in the accounting office of a public company and you see suspicious conduct like invoices that you think are doctored, if you see evidence that there are undocumented side agreements or round-trip transactions, if you're getting pressure to approve accounting treatment on a transaction that you don't believe has been accurately documented, those are securities law related observations. So you need a securities lawyer. At the same time, you also need somebody to advise you on employment law. And now with these retaliation provisions, the complexity with these court decisions, you need, this is the federalization of employment law in this space. And so you need someone who knows these retaliation provisions So you got to have somebody that does both. Someone like me, or another sophisticated securities lawyer who also understands these employment law issues, is somebody that I think is critical that an employee who's going through this dilemma, comes to for good advice.
You're really the first person I've also heard talk about the securities law aspect, and that while certainly the filings under Sarbanes-Oxley and Dodd-Frank impact securities law, it's really much more going to the analysis of the underlying facts and the claims. So I think that that's an important distinction that many listeners have not really focused on before, which is you must understand securities law, not just to file the claims, but even to understand them.
Exactly. Can I mention one other thing? I think reputation. The SEC found when it was writing these rules, and the Supreme Court even states it in its opinion in the Digital Realty case, that 80% of whistleblowers want to go internal. They want to report their information internally. Corporate employees, their main concern is they don't want stress in their life. They want to do their job, they want to work hard, and they want to do a good job. And when they're confronted with these dilemmas, with leadership that's trying to cook the books, or maybe not disclose things the right way, those are huge dilemmas and huge points of stress for these otherwise good employees that just want to, come in, do their job, and go home and spend time with their family. So it's critical that these employees understand that if they get caught up in something and they don't report it and they don't protect themselves by calling a lawyer and understanding what their rights are, they could be caught up in all of this, and they could have to testify in front of the SEC. And it's better that they understand their rights and responsibilities and obligations beforehand, so that they can be placed in the best light possible, in the best position possible to defend, not just get an award and have retaliation provisions, but to defend what they've done at the corporation. If they have this dilemma where they can either look the other way and approve the invoice and approve the accounting treatment, or they can stand up and say to the sales department, I can't approve this because this internal control wasn't followed here. So that dilemma is huge, and it shouldn't be overlooked. This is really what drives employees and causes stress.
So, Tom, it's been a few weeks now since the decision has come out. Certainly, people like you and I have been talking about it in conferences and social media. But I was wondering, have you seen any real changes yet, either in the number of reports to the commission or whistleblowing tips to the commission, or any questions at your law firm or your practice about things that have come up since this decision?
I have not so far seen an uptick in my practice, but I do suspect that as more and more articles come out on the internet and this becomes wider known, that we will. The only real thing that's impacted me is I've had to file a joint motion in court earlier this week to dismiss a Dodd-Frank claim. Luckily, we have the SOX claim because we made sure that our client who didn't come to us, who was fired before he came to us, but within the 180 days, so we did button that up. But the only way this has impacted me so far is I had to agree to dismiss a claim in one of our retaliation cases in federal court.
So, Tom, we're unfortunately near the end of our time, but I was wondering if someone wanted to find out either more about yourself or the law firm, how would they do so?
The best way to contact me is through my law firm email address. It's tsporkin@buckleysandler.com.
Well, Tom, this has been a fascinating exploration from your perspective of the Digital Realty Trust versus Summers case, and I hope we can continue the conversation in the future.
Thanks, Tom. I would enjoy that.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only weekly FCPA and compliance podcast taking a look at current events. If If you have any questions, you can email me at tfox@tfoxlaw.com. Thank you again for listening to this week's episode of the FCPA Compliance Report, and I hope you'll join me again next week. The FCPA Compliance Report is a part of the Compliance Podcast Network.